The detention hearing is an extremely important decision. A lot of things happen at that hearing, which a lot of people don't realize. I'm going to tell you one thing. In California, as in all states, there has to be an inquiry as to the paternity of the children. In other words, who's the father? And I don't mean the biological father. In California, there are, I think, 5 or 6 different types of fathers that are legally recognized. And so there's an inquiry, and a short part of the hearing is devoted to who's the presumed father. Now, what's a presumed father? Well, that's a whole 1-hour conversation. But suffices to say that if you are a father or believe that you are a presumed father, you should be at that hearing. It's not just for biological fathers. I'll give you an example. Mother and father have a child, bio-father have a child, the child's 5 years old. They get divorced when the child is 6 months old and the bio-father disappears. At 7 months, mother gets remarried to another man, and he has been raising that child as his own for the next 4.5 years. The gentleman who's been raising the man has significant legal rights in California. He could qualify as a presumed father, in my opinion. Now, a couple of years ago, California passed a law where a child could have more than 2 parents. So what happens in a lot of cases, presumed fathers make motions to be recognized, and they're non-biological fathers, and they want to be recognized by the juvenile court with respect to custody, visitation, and perhaps services given by the county in order to get the child placed back in his home. And I call them presumed fathers. It could be the same thing with the mother, the presumed mother. I think the actual term is presumed parent. That's one of the things that happens at the detention hearing. The next important thing that happens at the juvenile dependency detention hearing is the inquiry into ICWA. ICWA is the Indian Child Welfare Act. It's a federal law, and it's a very powerful federal law. Because there has been a sense that we have in this country taken advantage of American Indians, they get special treatment in juvenile dependency cases. And there's a whole set of laws that apply to them, which don't apply to regular non-Indian citizens. So there's an inquiry, and you want to make sure that the court is notified if there is any Indian ancestry in the family. Now, I'm not asking you, I didn't say, are the people registered in an Indian tribe? That's not the inquiry. The inquiry is, do they have any American Indian ancestry, blood running through their veins? And if the answer is yes, the court has to start at the very beginning taking on very special procedures. I'm going to tell you about a case that I'm aware of that happened in Ventura County. At the detention hearing, at the initial detention hearing, the judge asks the parents, do you have any American Indian ancestry? And both parents say, yes, we do. We're from a tribe of Eskimos from Alaska. And as the story goes, the social worker's attorney, the county counsel, tells the judge, hey, Eskimos aren't American Indians. ICWA doesn't apply. Well, the judge agrees with the county counsel, and they do the entire case. It goes on for months. They even terminate the parents' parental rights. Coincidentally, the case is appealed by the parents. They get a court-appointed attorney. And it just so happens the court-appointed attorney is an American Indian. And he realizes what happened at the detention hearing. He makes special motions and sets the entire case aside. In other words, it's thrown out, and they have to start all over again. Now remember, the parental rights were terminated, and somebody's going to adopt these kids. Well, since when they started the case over, since the mother had done everything, and the father, I believe, the kids went back to one of the parents. They don't lose them to foster care because they started the case over, but since the mother and father had remedied the situation and had taken all the classes that were necessary, done all the drug testing that was necessary, they got the kids back. And then the case was closed. So that's how important ICWA is, that ICWA inquiry. Now, here's the third and probably the most important thing that happens at a juvenile dependency detention hearing. What most people don't know is that you are entitled to what's called a no time waiver trial. Now, you may not want a no time waiver trial, but you're entitled to it. A no time waiver trial means that if your child is detained, you get to have a hearing, a trial on the matter within 15 court days. Not calendar days, 15 court days. And then you're entitled to have your disposition hearing, which is probably the most important hearing, and in a juvenile dependency proceeding within 10 court days after that. Sometimes those hearings, I won't say sometimes, many times, those hearings are done together by the juvenile dependency court. So there's no need for you to wait weeks or months to have a hearing. Now, as a matter of course, a lot of the hearings are set a month, 6 weeks, 2 months out. And there are very strict laws about this. But if you and your attorney don't enforce them, you'll lose them. And you'll be just stuck in the dependency system. And it's important that your case be resolved fast because there is something called family reunification services, and you only get a set time for family reunification services, and we'll talk about that in later hearings. So the best thing that you could do is to not waive time, ask for a no time waiver trial. Now, like everything else in the law, there's 1,000 exceptions. Sometimes you don't want to have a no time waiver trial. In other words, a delay in the trial might help you as a parent. But when you go in, you should know either way whether you want a no time waiver trial or you don't want a no time waiver trial, and you should discuss that with your attorney. If you have any questions regarding these special detention issues, please give me a call. 888-888-6582. That's 888-888-6582. The next video is going to be on the jurisdictional and dispositional hearing. Remember I said the dispositional hearing is the most important hearing in the juvenile dependency procedures.